Hi, Leanne. How are you?
Good, thank you. How are you, Michael?
Good. Always looking forward to our chats. Always learn so much from you.
Yes, likewise. I always find I pick up a new tip every time.
Well, it's always good to learn. Today, I have something I wanted to ask you about and share with others, and I know it's largely misunderstood. I find myself talking to clients and people a lot about it. But before we get into it, I think there's some people that may see this video and not know who you are. Some people might see it and not know who I am. So why don't we take a minute and introduce ourselves, and then we'll get right to it.
Sounds good.
Okay, why don't you go first?
Okay, so my name's Leanne Townsend. I'm a family law lawyer in downtown Toronto, and I'm a partner at the law firm Brauti, Thorning LLP. I practice exclusively in the area of family law, so including separation, divorce, custody access, support, division of property, all those issues. And I have a particular background in domestic violence and domestic abuse, as I was a Crown attorney for over 16 years and the lead prosecutor in the Etobicoke Crown's office in that area.
Very good. And for those who don't know me, I've been a full-time realtor for more years than I can count. And I frequently work from everybody from first-time home buyers to empty nesters going into assisted living and happy families, happy couples with kids and pets and, that sort of thing. But I also specialize in a couple of niche aspects of real estate. One of them being I'm Ontario's first divorce real estate specialist, which is, of course, is how you and I met, Leanne. Our paths crossed, and we work with different on behalf of mutual clients, which is why we always get to some really interesting conversations. So that leads to today's topic, and I want to talk about the matrimonial home for those who may not understand where I'm going with this. Often I will get people that'll call me. I know that they live in the city, for example, and they'll say, Michael, I want you to list the cottage, for example. And I'll say, well, we're going to need your spouse to sign spousal consent. And they'll say, no, no, don't worry about it because it's not their principal residence. And a lot of people think, excuse me, just the principal residence where they live every day of the year is their matrimonial property. And of course, I'm starting to educate them. A lot of people don't know this. Some realtors don't know this, that there can be more than one matrimonial property. I see you shaking your head. Of course, you're the lawyer. So here's what I'd like to ask you to start off with. What is a matrimonial property?
Well, matrimonial property is something in the family law realm that has special status if parties end up separating and divorcing. So it's an important legal distinction that needs to be made on a property. And essentially, in sort of everyday layman's language, it's a home. It doesn't have to be a house. It could be any type of home or residence where a couple is living, married or common law, although the property rights only accrue to a married couple. But it's a home where a couple is living and sharing their life. Essentially, they're sleeping there, they're spending time there, they're doing things together as a couple, as a family, if they have children. Those are like the general types of requirements that would result in something being designated a matrimonial home.
Okay. And so if it's not, let's say, their principal residence, let's use a cottage, for example, how is it determined if the additional property that's not a principal residence, how is it determined if it's a matrimonial property, and therefore, as a realtor, if we need spousal consent on listing agreements and offers and agreements of purchase and sale? How's it determined?
There's a number of factors that are looked at. One might be who paid for it, one might be title. But the most important one is, again, how is the residence or the property being used? For example, if it's a cottage, is the couple going up there every weekend and spending time there together in the summer and sharing it as a property that they enjoy spending time at together with their children, without children if they don't have children? Or is it a property that one person perhaps brought into the marriage, and they go, their spouse goes up there maybe once a year, twice a year at most, and it's not a property that they're both using together? So I would say the usage is like the strongest factor, but legally we would look at a number of factors before, determining whether it is a matrimonial property or not.
Right. So that's something, of course, I don't give legal advice, but that's something when people ask me further, I've often said to use an analogy because people can relate to analogies. If one of the spouses went there every single week for 10 years or every single weekend for 10 years, and one spouse didn't, that might be deemed not a matrimonial property. Whereas if everybody packed up the SUV and the family dog every weekend and every long weekend for 10 years, it would be. But does it matter if it was purchased together during the marriage or if one spouse owned it before the marriage? Does usage and what you just talked about, is that even relevant depending on who owned it before or if they bought it together?
Usage is very relevant. So, one party owned it before the marriage and brought it into the marriage, but it's being used, as a family residence or a family cottage, then it may very well, meet the criteria to be designated a matrimonial property. And,
Right.
one of the other key things with a matrimonial property is a right of possession. So, if something is designated a matrimonial property, then both parties have a right to be there, regardless of whose name the property is in. So that can lead to some challenges, when people are breaking up and they want somebody to leave and the property, say it's a cottage that's in your name and your spouse, wants to be there and won't leave and it meets the criteria for a matrimonial property, then you've got a problem. So it is a really important designation.
And okay, and so everything you just explained, my understanding is, so that's if somebody owned it prior to the marriage, but if they used it together for many years, then it can be considered matrimonial. But what about the opposite? So if a couple got married, they both came into the marriage with very little or nothing, and then during the marriage, they bought the cottage together, but only one spouse ever really cared to go and the other spouse didn't want anything to do with it. The fact that they bought it together during the marriage, is it automatically a matrimonial property or is it still based on usage?
Well, it's still a joint property, so there's still going to be, financial entitlement to both parties. I think that that's a question that's a little more gray, and that's what a lot of these are. So, that might be something where one party is saying, yes, it is a matrimonial property because both parties bought it together. What was their intention when they bought it? Might be something that's asked. Was it intended to be a family cottage or a second residence, and then the other party for whatever reason just didn't like going there, so ended up not going there? That could be relevant. You're going to look at a bunch of factors in that situation, and there could be arguments on both sides as to whether it is a matrimonial property or not.
Okay. And the last question that comes to mind for today is, well, as you know, I'm frequently teaching other realtors or mentoring newer realtors on some of the intricacies of selling matrimonial properties. And sometimes when they don't understand when spousal consent is or is not required, they think it's just safe to sign everything and cover all bases. And the little understanding I understand about the law is that can also be dangerous because if a couple is splitting up and one spouse is trying to argue that the other spouse is not entitled to a share of it, and then they go ahead and sign spousal consent because their realtor told them to, if it ever gets to court, a judge could effectively say, well, you are admitting to it being a matrimonial property. So I always tell realtors, don't just get signatures for the sake of covering all bases. Take an extra minute or two and check with the lawyers, whether the couple has a lawyer. If they don't have a lawyer yet, they could call you, they could call me, and I have access. But get legal advice before you just start throwing signatures everywhere. Is that fair to say?
Yeah, that's correct. Because again, as you mentioned, if the realtor decides to have the spouse sign the consent form, then you're essentially suggesting that, the parties are agreeing that it is a matrimonial property. And, when the one party ends up retaining a family law lawyer for the purposes of separation or divorce, and they decide, like, this doesn't meet the criteria for it, and, you shouldn't have to endure the financial implications or the, rights to possession or things like that accrue if it's a matrimonial property. But you have that form signed, that's going to be challenging for the family law lawyer to unwind or to deal with. So it's always better. I know people don't like talking to lawyers, and that's because, generally we charge for our time because that's how we make our living. But, there's certain things where you can save yourself a lot of money and a lot of aggravation and a lot of problems by spending that little bit of money and speaking to a lawyer before making a mistake.
Great advice. Yes, I agree. I agree 100%. Always a pleasure, Leanne. We always learn from each other, and I like this type of format because now we're sharing information with people that might find it interesting as well. So thanks again for your time. Great chatting.
I always enjoy chatting with you as well, Michael. Have a
Thank
great
you. And I look forward to the next time.
day. Me too.
Okay, have a great day.